Good afternoon, participants. Welcome to the final round, 31st National Moot Competition 2020. Participants, please state your team.
The petitioner's team code is P.
Okay. The respondents.
Team code H.
Okay. Team P, how would you like to divide your allotted 45 minutes?
15 minutes per speaker and 5 minutes for rebuttal and intimation through chat box, please. You're not audible, court officer.
Am I audible to you?
Yes.
Each team will get a total of 45 minutes now. So how would you like to divide your time?
Then 20 minutes per speaker and 5 minutes for rebuttal.
Can you please repeat it?
20 minutes per speaker and 5 minutes for rebuttal.
Okay, thank you.
Thank you.
Team H, how would you like to divide your time?
17 minutes for speaker 1, 24 minutes for speaker 2, and 4 minutes for the surrogate.
Thank you, ma'am.
Participants, may please note I am going to read the rules. The allotted time for each team is 45 minutes for the finals, which may be extended at the discretion of the Hon'ble. The court officer will be intimating the remaining time for each speaker at regular intervals. Any additional time taken by the first speaker will be reduced from the second speaker's time. Participants are to keep their video on at all times. Now let's wait for the Hon'ble bench.
एक बार कहीं वहां से अनम्यूट कर दीजिए। वो तो कैंसिल करवा दीजिए। हेलो
Yes, sir.
मैम, एम आई ऑडिबल?
Yes, sir, you are.
ओके मैम। Yes, you are muted actually.
Your Lordship, am I audible to you?
Only now.
Thank you, sir.
We can begin.
Sure, sir. Good afternoon to the Honorable Bench. We're extremely honored to have the esteemed presence of this Honorable Bench in the final round of the 31st National Moot Court Competition 2022, conducted by Kerala Law Academy in association with Kerala Law Academy Moot Court Society. Kerala Law Academy Law College was established in 1966 by the legal luminary Dr. late N. Narayan Nair, sir, who is the founder head of the institution. It's a seat of excellence in legal education, consultancy, research, and in pioneering law reforms. The All India Moot Court competition put forward by Kerala Law Academy Moot Court Society has a legacy of 31 years in finding out the best mooters from law institutions all over India. The final round of this competition is presided over by three eminent judges of our apex court. Honorable Mr. Justice V. Ramasubramanian, sir, who is a sitting judge of the Supreme Court of India and also a former Chief Justice of Himachal Pradesh High Court. His Lordship also served as a judge of Madras High Court as well as Telangana High Court. His Lordship practiced mainly in civil and constitutional matters and was specialized in service matters. Next, we have Honorable Mr. Justice C.T. Ravikumar, sir, enrolled as an advocate in 1986 and mainly argued civil, criminal, service and labour matters. His Lordship became a judge of Kerala High Court in January 2009. Justice Ravikumar, sir, is the fifth judge who got elevated to the Supreme Court directly from the High Court of Kerala. And finally, we have Honorable Mr. Justice M.M. Sundresh, sir, who is an incumbent judge of the Supreme Court of India. Enrolled as an advocate in the year 1985, he worked as a government advocate between 1991 to 1996. His Lordship has extensive practice in civil, criminal and writ jurisdiction in the Honorable High Court of Madras. His Lordship has elevated to the Supreme Court of India on 31st August 2021. We are extremely privileged to have their esteemed presence for the final round of our moot court competition. With your Honorable Bench's permission, shall we move on to the briefing session?
Yes. Yes.
Thank you, Your Honorable Bench. The Honorable Bench may kindly note, the final round is assisted by Arjun PM, Sri Durga MU and Gopika Shashi as court officers. The total allotted time for each team is 45 minutes, which may be exceeded at the discretion of this Honorable Bench. The court officer will be intimating the remaining time for each speaker at regular intervals. This time could be extended by this Honorable Bench discretion. With your Honorable Bench's permission, shall we begin the session?
Yes.
Thank you, Your Lordship. Please note, this is the final round of the 31st National Moot Court Competition with Team Code P and Team Code H. Team Code P shall be arguing for the petitioners and Team Code H shall be arguing for the respondents. The first counsel for the petitioner side may begin.
Am I clearly audible?
Yes.
Yes, you are.
Greetings to the bench. This is the counsel on behalf of the petitioner in the case of Sahupal versus State of Dharmastan. The counsel seeks permission to refer to the bench as the Honorable Judge.
Yes.
If the Honorable Judge is well versed with the facts of the case, the counsel would like to proceed with the issues at hand.
Yes. Yes.
There are four main issues that the counsel for the petitioner would be dealing with today. The first two by myself and the last two by my co-counsel. The issues that I will be dealing with today are whether sections 123 and 124 of the Evidence Act 1872 is ultra vires the Constitution. Secondly, whether the documents related to whether the government may be directed to produce documents related to sources before the Honorable Court. The third is whether a CBI investigation may be directed into the case of Nasosis, and finally, whether a compensation of 50 lakhs may be granted to the petitioner in the present case. Moving on to the issues at hand, the first is whether sections 123 and 124 are ultra vires the Constitution. The first and foremost thing that must be established is that in the case of section 123 and 124, there is no presumption of constitutionality, wherein this law, which was enacted in 1872, being a pre-constitutional legislation.
Council, please tell us what those provisions are first.
Yes, Honorable Judge. Section 123 states that unpublished official records relating to affairs of state shall not be disclosed except with the consent of the head of the department concerned. Section 124 states that communications in official confidence made to a public officer shall not be disclosed if the officer is of the opinion that such disclosure would be injurious to public interest.
All right. All right. Now you are challenging these two provisions, right?
Yes.
Right. Please tell us on what legal premise you can lay a challenge to a provision of an act.
It's Article 13, wherein all laws that are in contravention of the fundamental rights are void to the extent of the contravention.
That merely expresses, Article 13 merely says the effect. On what legal premise, on what legal ground you can challenge an enactment or a provision on enactment. You are trying to seek a verdict from us to declare it unconstitutional, right?
Yes, Honorable.
What are the legal grounds? What are the parameters under which a provision of enactment can be challenged?
Wherein in this present case, we are challenging section 123 and 124 on the grounds of violation of Article 14, 19, and 21.
I think you have not understood our question.
Could you please repeat the question, Honorable Judge?
We are only asking on what legal ground, on what legal basis you can challenge it, right? Supposing that, let us assume there is an administrative order. You can challenge it on the ground of violation of principles of natural justice, correct?
Yes.
You can challenge you can challenge it on the ground of lack of jurisdiction, correct?
Yes.
Similarly, when a challenge is made to a provision of an act, what legal ground on which you can challenge that provision?
Again, in this case, I believe that the procedure that is given in section 123 and 124 are arbitrary and they give by discretionary powers.
All right. But, so you are saying if the provision of an act is arbitrary, it can be challenged by on the ground. It should be declared as ultra vires of the Constitution. Is it correct?
Yeah. Yes, since it violates Article 14.
All right. You require mere arbitration, arbitrariness, or the arbitration should be manifest then?
There must be manifest arbitrariness where by discretionary powers, with no other guidelines of tempering this discretion.
What we want you to argue is this. What is the difference in making a challenge to an administrative action and the provision of enactment? There are only certain legally permissible grounds which will be available to you to challenge an enactment. Can you just tell us on what legal permissible ground you can challenge?
And before proceeding further, before taking up challenge against this section 123, have you gone through section 91 of a CRPC?
Section 91 of CRPC? No, Honorable Judge.
No. You think that it is absolutely irrelevant?
I'm not aware of the provision of section 91.
91 CRPC.
Yeah, I'm not aware of the content of the provision.
Yes.
All right, you proceed. Now we are only telling you the fundamental principle of law is this. When you want to challenge the provision of an act to declare it unconstitutional, ultra vires the Constitution, you must say that it is per se against the Constitution. Number one. Number two, you must say that it is against the fundamental rights affecting the rights of the parties.
And the legislative competence.
Number three, what you say that there is manifest arbitration involved. Number 4 will be lack of jurisdiction. For example, it may come under the state list. A central government would have passed this act. Therefore, there is a lack of jurisdiction is available. So under what legal premise you are trying to challenge this?
It would be under the 2 grounds mentioned here, wherein it's manifestly arbitrary, and also the fact that it violates the fundamental rights of under Article 19 and 21 as well. Wherein we are not claiming any the ground of legislative competence in this case, but we're solely going through violation of fundamental rights guaranteed under Part 3.
All right.
Moving on with the first point is that there is no presumption of constitutionality in the present case, wherein a pre-constitutional provisions, that are section 123 and 124, where it was enacted by a body which did not represent the will of the people. In this case, the presumption of constitutionality that is usually attached in other laws is not attached in the present case, which means that this additional burden of proving that this law is unfair or arbitrary in spite of the presumption is not on the petitioner. The second point that I would like to bring to the court's attention is that the present form of section 123 and 124, the provisions I've already just mentioned. However, the application of the provisions have been expanded by the courts in several cases. The major point to be noted is that the court held 2 things, wherein the question of injury to public interest would be decided by the court as the final authority. And finally, in the process of deciding whether public interest has been affected or not, the court can inspect the document. However, this is a way of looking at the law wherein the court has construed it to serve the ends of justice. But merely administering a law in a way that's constitutionally valid would not make the provision itself constitutionally valid. Wherein, in spite of the express provision to section 162 saying that the court can't inspect the document, the court has nonetheless interpreted it to mean that the court can inspect the document while looking into the test of public interest. What this means is that at the present, the very text of the language, the very text of the provision, the language contained therein ends up having implications which are ultra vires the constitution and violate fundamental rights, which I will explain in just a moment. What are the fundamental rights that are in question here? Is it 3, Article 14, 19, and 21, the golden triangle. The first is that of Article 14, wherein through judgments, the court has held that it goes beyond merely right to equality, but it goes beyond right to equality, wherein unequals are to be treated unequally. It goes beyond that to even include matters of reasonableness and unarbitrariness, wherein any decision that must be made must not be arbitrary in nature. In this case, when it comes to section 123 and 124, there are no guidelines given as to what are the considerations that must be kept in mind while allowing disclosure or non-disclosure in a particular case. Section 123 explicitly merely states as the officer deems fit. In this case, this gives wide powers wherein the officer can choose any reason that deems fit to the officer itself, which may range from any private interest of expediency, or it may even take the form of.
Why you are saying that it is an officer?
The head of the
Are you now saying about 123 or 124?
The 123.
Can you distinguish these two?
Yes. Section 123 I believe there are 2 major distinctions. One is about the unpublished records being the subject matter of section 123, and in section 124 it's more related to communications in official confidence. The second is that here the head of the department concerned can give permission as he deems fit. However, in section 124, the public officer to whom the communication is made can give permission depending on injury to public interest, again based on the opinion of the public officer itself. So I would like to first
we take it that D has the challenge to this provision which you seek to impugn. They actually facilitate the contention of the respondent. Now, supposing 123 and 124 as they stand in the statute today will enable them not to disclose. Is it your case?
My case is
What is
that
your understanding of so 123? It says, as my brother has put it, he speaks about unpublished record. What do you mean by unpublished record? Is it
unpublished
communication or is it a record? How do you interpret this?
unpublished official records relate to documents that are not available in the public domain or cannot be easily accessed by the public at large.
You are actually missing one crucial ingredient. You said document. One crucial ingredient that would attract this.
Is the Honorable Judge referring to section 162?
123. One crucial factor would attract this particular provision.
Whether the matter relates to affairs.
I will say one more thing. To claim protection, if that particular document should be related to what?
It must relate to affairs of state.
That is the crucial thing. It should the affairs of the state.
Absolutely, Honorable Judge. Wherein
now, if your allegation is that in the guise of undertaking an exercise, presumably pertaining to the affairs of the state, they go beyond. Correct?
Yes.
So you have no difficulty if this instrument is used to track the criminal activities or certain people who are required to be monitored. Do you have an objection for that, or is it your case that taking advantage of this instrument, they are snooping on others? What is your case?
My case is that there is no certainty that they'll only track criminal activities using this provision. Wherein there are cases where, in interest of expediency or merely to protect the defense that they have raised, it's very possible that a protection under section 123 and 124.
If that's the case, on the premise that there is a likelihood of misuse, can a provision be declared unconstitutional?
Though the likelihood of misuse cannot be the only ground for declaring a provision as unconstitutional, there's also the fact that here it's not discretion with guidelines and then possibility of misuse. Here there's discretion with no way of streamlining or channelizing it, but and the possibility of misuse, it becomes greater and even more manifest and prominent in this case.
Okay.
Moving on to what I was saying about Article 14, just quickly going on to Section 124 as well, wherein in Section 123, I had already mentioned that what relates to affairs of state and what is injury to public interest. These, even forgetting injury to public interest, because the text of the language doesn't say anything about public interest, it rather just mentions as the head of the department deems fit. So there is no mention of what constitutes this. No straitjacket formula can be evolved with regard to matters where, since considering the dynamic nature of the state, affairs of state may keep changing, and the same when it comes to public interest. However, certain guidelines and at least things to be kept in mind which reflects application of mind while making a decision is extremely important to show that the decision was not made in an arbitrary manner. In Section 124 as well, where the public officer may disclose or withhold permission depending on injury to public interest, it entirely depends on what the officer thinks is injuries to public interest, wherein there is no given guidelines as to what must be considered with regard to what constitutes injury to public interest. The second is the nature of Article 19, wherein in Article 19(1)(a), the important right of freedom of speech and expression is given, and the right to know has been held to be part and parcel.
May please note you have 5 minutes.
Oh, thank you. The right to know is part and parcel of Article 19(1)(a). So in such a case where a crucial right has been given under Article 19, where the public has a larger interest to know on matters of public importance, because it's only through such knowledge and information and access to such information can they fairly participate in the discussions and discourses of democracy. Now, in this case, when considering again that there is wide conferment of powers here, the executive itself cannot fairly take a consideration of the right to know. The right to know is not given its due and fair weightage which it deserves, wherein in the matter of balance of public interest, the public interest warranting disclosure and the public interest asking for non-disclosure, this fair balance will not be considered by the executive, which itself has a narrow departmental angle in such a case. The last is that of Article 21, wherein in this case, the personal liberty being deprived, any procedure used to take that away must also be not unreasonable, unfair, or unjust. And in such a case, where this procedure that's given for taking away the personal liberty, where this procedure of the executive being given the final say, not based on any valid or at least known considerations to disclose or not disclose a document, is squarely against Article 21 as well. And this is the reason why the petitioners contend that Section 123 and 124 is ultra vires the Constitution. I would quickly like to summarize my second issue as well. The second issue is that of whether documents related to resources may be produced by the government in the present case. I've already mentioned before that the courts have developed a system of balance of public interest, where in every case they can take the affidavit that's given by the executive. If they're not satisfied, they can inspect the document, and if they're still not satisfied, they can take oral evidence as well. So in this case, balance of public interest is the important point here, where the point to note here is not there is public interest versus private interest. It's not a matter of the public interest of whatever claim that is raised by the state versus private interest of the litigant here. There is public interest versus public interest, whereas public interest asking for non-disclosure and public interest in a fair administration of justice, that the court has all access to all relevant materials. And secondly, that the larger right to know of the public at large is also protected. So this is the balance, the test of balance that is followed. The second thing is that the disclosure is the norm and secrecy is the exception, only when the strictest public requirements demanded. In this present case, there's been the allegation of national security that has been raised in the present case. However, just merely raising the specter of national security without giving any more explanation as to the nature of its effect on the public interest of national security or any other details regarding the software itself means that the public is largely left in the dark regarding the use of resources. In this present case, with regard to resources, the only thing that has been agreed across the spectrum is A, resources exist as proved by the forensic report of the petitioner. Other than that, the questions of what were the circumstances surrounding the use of resources, the extent of the use of resources, who has authorized or unauthorizedly used the software, are all questions that must be answered to find out if there has been any grave violation of fundamental right that has taken place in this case. Now that we have absolutely...
Speaker 1, may please note you have 1 minute remaining.
Now that we have absolutely no clarity on primary questions regarding the use of resources, the balance of interest must also remember this point, wherein when there is no material suggesting on behalf of the respondents as to how national security is affected in the present case, the petitioners have already contended that in the present case, the public interest of the right to know is even more apprehended, and the balance of public interest tilts in this side because A, primary questions aren't answered, and B, the majority of the information available out there is based on newspaper reports. So when you don't have credible information from authorized sources, it is going to create more and more of turmoil out there, wherein there is going to be a lot of fear mongering and the lack of and the void created by lack of information is just going to create more and more misinformation. These are the arguments on behalf of the petitioner. The co-counsel will continue.
Please answer one question.
Yes.
Are you proceeding on the basis that resources has been used, or primarily you want to find out whether that such a spyware was used or not?
Honorable Judge, resources has been used, but who has used it remains a mystery.
What is the proof you have produced to show that it's used?
A forensic report has been produced along with the petition.
Forensic report has been produced?
Yes, Honorable Judge.
Where?
may I refer to the proposition which states
Yes.
under 1 second, just.
Yes. And what is the purpose of constituting a committee?
Just 1 second, Honorable Judge.
That is already, that is already there.
Where do you find it that there is a forensic, the forensic?
The forensic report is given in paragraph number 11 and on page number 6. Where in the last line of paragraph 11.
That is newspaper. Newspaper.
Newspaper report.
May I read the line, Honorable Judge?
Yes, please.
It says the newspaper reports regarding the use of nososis and a forensic analysis report stating that Mr. Sahupal's phone showed clear signs of nososis spyware activity between February 2020 and January 2021 were attached in the petition.
Who is the forensic? You have any material about this forensic laboratory which produced this report?
It's not mentioned in the proposition.
All right. And was nososis possible of being used only by government, or it is also possible of being used by other people?
There is certainly a possibility that it might have been used by private entities, and hence the plea for production of documents.
That is so. How do you proceed? How does your writ petition proceed? On the basis that it was used by the government, and therefore the government is obliged to order a CBI investigation and pay you compensation, etc.
All the documents that are available which are related to nososis may be produced before the Honorable Court. If there were no documents that were available at all regarding nososis, then there was no reason to take a protection under section 123 and 124, Honorable Judge. My co-counsel will continue the case for the petitioner.
Yes.
Highly obliged. This is the co-counsel on behalf of the petitioner in the case of Sahupal versus the state of Dharmastan. I will be dealing with the last two issues at hand, the first of which is whether the court can direct a CBI investigation into the matter of nososis. The petitioner humbly contends before this honorable court that there is an urgent need for a CBI investigation to be directed by this court in the matter of use of nososis. While considering this question, two main considerations should be bear in mind. First is whether the court can direct an investigation, and the second is whether the court should direct an investigation. On the basis of whether the court can direct an investigation, I would like to expound a bit upon the evolution of the jurisprudence on direction of court into CBI proceeding. This was mainly evolved in the case of State of West Bengal versus the Committee for Protection of Democratic Rights, when the primary issue under consideration was whether the court can direct a CBI investigation into, in the absence of general consent of the state, into the commission of an offense within the boundaries of the state. The court had held that yes, the court can direct a CBI investigation into the commission of an offense even when general consent in the state is absent. The court furthermore held that because the Supreme Court is the protector of civil liberties, this power extends to doing complete justice and in the fair administration of justice that is dispensed by this court. Interconnectedly, it is also beneficial to mention that the state is also constitutionally obligated to protect the right to life, liberty, and property of a person. In furtherance to this, the Supreme Court has expounded upon the meaning of Article 21 of the Constitution, wherein the right to have a fair and impartial investigation was held to be an individual right when allegations of fundamental rights, when allegations of violation of fundamental rights are mentioned. It must be noted that the power to safeguard fundamental rights are a limitation upon state action, and it is important to ensure that a fair and impartial investigation will be conducted into any allegation that is raised for the violation of fundamental rights. It is for this reason that we allege that a CBI inquiry should be directed into this matter. Now, the most obvious question arises, why not a local police inquiry? Why not the state police? I would like to direct the court's attention to the Moot proposition, wherein there has been doubt cast upon.
Did you ever attempt to lodge a complaint before any police?
My apologies, that has not been done.
Came to court with a writ petition seeking a mandamus. Did you ever approach any police?
That has not been done, Honorable Judge.
And what is the law on the point?
The petitioner is entitled to bring about a writ petition for violation of fundamental rights, and we believe that it is the state's as well as the court's duty to look into these allegations.
All right. Now you already placed on record Section 6 of the Delhi Police Special Establishment Act, right? Now,
Yes, Honorable Judge.
let us assume the respondent is taking a stand that general consent is being withdrawn. Does the court have a power even thereafter?
Indeed, Honorable Judge.
Contrary to the statute? Because the offense.
I'm sorry, could you reiterate, please?
Any offense will be territorial, correct?
I'm sorry, could you reiterate, please?
No,
There's a lot of
any
disturbance.
offense,
Okay,
if the very fact consent is given,
okay.
presupposes the admitted position that the offense alleged takes place in that place, correct?
Yes.
That is why consent is given. If the consent is withdrawn, then how will the CBI will have jurisdiction under Section 6?
The direction of the CBI to look into this matter, sir,
In
is
the
not.
absence of any complaint, that is why we asked you the question. In the absence of any other complaint.
I'm sorry, could you reiterate,
In
please?
the absence of any complaint,
Yes.
and in a case where the state has withdrawn the general consent under Section 6,
Yes.
will the court still have the power to issue a writ of mandamus to constitute a special team of CBI and then investigate?
Indeed, Your Lordship, in the case that I had mentioned, the court had explicitly mentioned that the powers of the Supreme Court to direct the CBI investigation are independent of the powers that are granted to the Union to direct the CBI investigation under Section 6 of the Delhi Special Police Establishment Act. Therefore, the court, in the interest of doing complete justice and as the protector of civil liberties, does have the authority to direct the CBI investigation to look into the matter of resources in the state of Dharmistan, even in the absence of general consent of the state.
Are you supported by any decision on that point?
Indeed, Honorable Judge.
There was only a general consent. There was only a general consent that was now withdrawn. That is your case. It is withdrawn. Despite
Yes.
the withdrawal, now you are coming up for seeking a prayer, seeking this relief.
Yes. The case at point would be the state of West Bengal and others versus Committee for Protection of Democratic Rights and Others, which is a 2010 judgment of this very honorable court.
No.
Wherein this issue explicitly was discussed, and this was the express decision that was arrived at by this honorable court.
All right, can proceed. Yes.
Now, the next obvious question arises as to why a national agency, why not a state agency? We would like to support our argument on this point by the very case that we've been relying upon since the beginning. Because in the Moot proposition, there has been doubt cast on the Dharmistan State Police, wherein they have been accused of, in express words written in the Moot proposition, detection of crimes for collecting information regarding political opponents, religious leaders, and journalists by way of use of resources. It must be pointed out that the petitioner himself is a journalist, and any investigation conducted by the state police would lack credibility because the shadow of doubt has already been cast in the state police. It was for this very reason that the West Bengal police, in the case of state of West Bengal and others versus Committee for Protection of Democratic Rights, was not allowed to investigate into the matter that was raised via writ petition. It is for this reason that we strongly urge for the court to direct a CBI investigation into this matter, as any investigation, even if conducted with the ideal amount of impartiality, would lack credibility in the eyes of the public and would not work towards restoring public trust, which, as mentioned by my co-counsel right now, is of grave importance here.
Yes.
If the court is satisfied with the arguments at hand, I would like to move on to the last issue for
Before that,
consideration.
please tell us
Yes.
on what factual premise the court can order a CBI investigation. Do you require certain material which are not disputed, based upon which an investigation can be ordered in a given case, or mere allegation, however serious it may be, would be sufficient enough. Now, in this case, we already told you that you are relying upon one report and other than the newspaper reports, number one. Number two, there is no material to show that the allegations made in the petitions are true, to the effect that the privacy of individuals being affected. Perhaps they may use it for by any other public purpose, just to to trace the illegal activities of committed individuals.
Not only that, paragraph 11, it only says that the forensic report confirms Nosos's spyware activity between February 2020 and February 2021. So, but your writ petition proceeds on the basis that this spyware was bought by the state.
I would like to.
Written here that the spyware, the who engaged the spyware, what could be traced by the forensic report is only the spyware activity, but who hired it is not mentioned there.
Indeed, your lordship. Indeed, your lordship, and that is actually one of the points that we're proceeding on. There is no clarity as to who is using the spyware. The reason why we have initiated action against the state.
What we're saying is, in the absence of any material, to come to a prima facie view that it is the state who procured it and thereafter letting it to be used by snooping on other individuals, how will the court enter into that field?
Honorable Judge, that is
yes.
Honorable Judge, that is not what the petitioner is trying to contend at this point. The petitioner is trying to contend that the fundamental right of the petitioner was violated. There is no clarity as to who violated it, but the court, as the protector of civil liberties, and the state, which has a constitutional obligation for protecting the life, liberty, and property.
Be very careful when you make your submissions, because that will be destructive of your argument. If you say that there is no clarity on who did it, then why do you want a CBI inquiry on that? Then let there be a complaint, then let the state government go into that, because nobody knows who has done it.
So the right to privacy of the petitioner was still violated, and the petitioner seeks redress through an investigation.
From the state.
I'm sorry, could you reiterate, please?
See, without knowing, you are actually in a dilemma, whether it is done by the state or by some other private party. Still, you are claiming compensation from the state.
Yes, because the state has a constitutional duty to protect the life, liberty, and property of a person, sir. Because the state has failed in its constitutional duty to do so.
Is accepted for every offense, state has to compensate, because it's a offense against society, and so state is expected to prevent that offense. So whenever an offense takes place, state has to step in and compensate the victim. Is it your case?
Sir, the compensation should only be granted when it is the last practical mode of redressal. In this case, the data of the petitioner was compromised. This data, even if it is deleted from the third party, or even if it is brought back to the petitioner, it is still seen by a third party. It was sensitive information which was divulged to a third party. And this.
What is the principle governing compensation? When will the question of compensation arise?
When there has been a violation of fundamental right.
That has to be established, right?
Yes, and that is the reason why we're seeking a CBI inquiry.
That's true, but there has to be a CBI inquiry. There has to be an investigation. The investigation should unerringly point out to the state, and thereafter, the court has come to a conclusion that state has done it, and because of the state action, the fundamental is violated. And thereafter only the question of compensation would arise.
Indeed, Honorable Judge, that is the procedure to be followed, and that is the reason why we're demanding for the procedure to be followed and then compensation to be granted.
Okay.
Then one more thing. You said that despite the withdrawal of the general consent, this court could issue a direction for CBI inquiry.
Yes.
And to buttress that point, you relied on the West Bengal decision 2018 10-3 thesis.
Yes.
Can you say what are the conditions, twin conditions which are required to make that particular decision applicable?
Can you please elaborate? I don't seem to have comprehended your question.
You relied, you said that you are entitled to get a direction
Yes, the
for
court is
CBI
entitled.
inquiry,
Yes,
despite the fact that the general consent given was withdrawn by the state.
yes,
And for that purpose, you relied on the West Bengal decision.
yes,
And twin conditions have been laid down by this court to say that even in such circumstances, invoking the power under Article 32, this court can issue such directions. Can you say what they are?
I may not be able to precisely pinpoint the conditions, but as far as I
So when
understand
you
it,
are relying on a particular decision, you must be able to make that decision squarely within the decision. Otherwise, how you can say apply this?
yes, Honorable Judge. So as far as I have comprehended the decision, I believe that in the interest of doing complete justice, and when the state authorities would be inadequate in concluding the investigation successfully, the CBI may be required to intervene by this Honorable Court.
One more question which is relevant.
No, I think counsel, we are trying, let me explain to you why the question is put to you.
Okay.
The CBI does not have original jurisdiction, correct?
Yes.
Right? So it merely takes over the investigation. Correct?
Yes. Yes. In most
So-
cases, yes.
So when a cognizable offense is made out, correct?
Yes.
In a particular place, and an FIR has to be registered. The first under section 154 of the Criminal Procedure Code, a cognizable offense is made out, then a case has to be registered.
Okay.
Then the question of investigation by which agency would arise.
Okay. Okay.
Therefore, we are asking, can you say that even the investigation to start with should go with the CBI? If you say so, what are the facts involving the case which you rely upon from the West Bengal state versus CBI? Which obviously we don't want to say because subject to further test, that judgment is subject to further scrutiny. But nonetheless, can you say that court has got power to direct the CBI to take the role of the state police?
I
Even
believe this.
without a complaint.
Can you reiterate the last part, please?
No, even without a complaint.
Okay.
Even without a complaint, on the basis of the averments made in a writ petition filed before the court, can such a direction be issued? Now, please, why we are saying this, there has to be in an FIR, correct?
Yes.
Unless there is an FIR, unless it's a case of preliminary investigation, which stands on a different footing, there is no question of investigation by an agency.
Yes.
So therefore, under those circumstances, can you say that notwithstanding any complaint given, notwithstanding a pendency of any complaint before the state police, the CBI can be directed to go into the allegations made? Now we are at the stage of mere allegations, correct or wrong?
Yes. Yes, we are.
You make out an allegation through your petition.
Yes.
So placing reliance upon two reports, one among them will be a scientific report, and other will be the newspaper report.
Yes.
So can we understand under such a circumstances, can the court direct?
Sir, I am not able to precisely answer your question because of the lack of legal knowledge on my part, and I apologize sincerely for that.
Please say it in your own way. No problem. Just say it in your own way. No difficulty. We are trying to understand you. That's all.
But in this case, we believe that the CBI should be directed to.
Your case, you can already, because your case is, when it comes to the constitution, there is no fetters on the court because it's a constitutional court.
Yes.
Therefore, what you are saying, if the court is prima facie of the view, there is a violation of Article 14, 19, or 21, as the case may be.
Okay.
The duty of the court is to protect constitution, and therefore the investigation by the CBI is only incidental thing.
So yes, but here the position of the petitioner should also be considered, because the petitioner cannot turn to the state authorities, because the shadow of doubt has already been cast on the state authorities. So the next authority that the petitioner approached was the High Court of Dharmastan, from where this case was transferred to the Supreme Court of India before this honorable bench. And therefore the CBI is also therefore the petitioner is also asking for a national level agency to investigate into this matter, so that an efficacious and an impartial investigation can be conducted into these allegations.
One last question. See, you said that the spyware, by this action, there is an intrusion into the right to privacy. Whether there is any specifically mentioned fundamental right to privacy?
Right to privacy has been given the
Is
pedestal of
it a fundamental right, explicitly or implicitly? In what manner what is your understanding on that?
It is included in Article 21 under the right to life and personal liberty.
What is the basis for that contention?
That life does not mean a mere animal existence. It also includes all other requirements that a man needs to make his life more fulfilling and wholesome. And one of such requirements is privacy, that is free from unwanted interference, the right to be left alone. And
Can
that is why.
You say which decision of the apex court, this court which declared that it is a fundamental right?
I believe it was the case of K.S. Puttaswamy versus the Union of India, which is a 2017 judgment of this court.
And what is the declaration?
That right to privacy is included in the right to life and personal liberty under Article 21.
So is such a right is unbridled and unrestricted right?
The right to privacy is certainly a qualified right.
What are the factors to say that it's qualified? What are the circumstances you can say?
If the right to
yes.
Just a clarification, Honorable Judge, are you
Speaker
asking?
2, may please note you have 1 minute to.
Okay, thank you very much. Honorable Judge, are you asking about the test of personal liberty that was applied in the case of privacy? I believe that's the case of legality, proportionality, and reasonability.
All right, you can wind up because you have 1 minute.
The counsel for the petitioner humbly contends before this court that a CBI investigation should be ordered into the matter of use of resources, so that an impartial, efficacious, and an unbiased investigation can be conducted. Moreover, this is where I conclude my argument. Thus, it is humbly submitted before this honorable court that sections 123 and 124 of the Indian Evidence Act of 1872 can be declared null, void, and ultra-vires to the Constitution of India 1950. If the honorable court has dealt adequately with my arguments, I would like to move on to the prayer.
No. Okay.
I'm sorry, I could not hear the answer.
All right, you have completed?
Yes, Honorable Judge.
Right.
I think we have discussed all facets of my argument.
Oh.
Wherefore, it is humbly prayed to this honorable court that in light of the issues raised, arguments advanced, and authorities cited, the honorable court may be pleased to hold that the petitions filed by Mr. Sahupal are maintainable under Article 32 of the Constitution, to direct a CBI investigation into the matter of use and lawfulness of use of resources, to declare sections 123 and 124 of the Indian Evidence Act as ultra-vires to the Constitution, to order production of documents related to resources before this honorable court, to grant compensation of rupees 50 lakhs for violation of Mr. Sahupal's privacy, and pass any other order, direction, or relief that it may deem fit in the interest of justice, equity, and good conscience. With this act of kindness, the petitioner shall duty bound forever humbly paid. The council rests its case.
Yes. All. I call upon the respondent side.
With the honorable bench kind permission, shall we start the respondent side argument?
Yes.
The first speaker for the respondent side may begin.
Greetings to the honorable bench. May it please the court. This is a counsel for the respondents appearing in the matter of Mr. Sahupal versus State of Dharmastan. With the kind permission of the bench, the counsel would put forth that the counsel would be dealing with issue number 1 and 2 in the present matter, and the remainder of the issues would be dealt with by co-counsel. If the counsel has permission of the bench, the counsel would like to proceed with the arguments.
Yes.
The counsel would take this opportunity to put forth at the very inspection of the case that the current petition is not maintainable before the Honorable Court. 3 grounds for this petition not being maintainable will be put forth by the court. The first being that no prima facie case has been made out on merit. And this would be argumented by the counsel in the further arguments and also would be argumented by my co-counsel in his arguments. Second being that the provisions 123 and 124 of the Indian Evidence Act 1872 have been repeatedly upheld as being constitutional, and therefore no remark regarding their unconstitutionality could be withheld. Thirdly, Your Lordship, that in the present case, no fundamental rights of the petitioners have been infringed, and the same would be elaborated by my co-counsel in his arguments. As Your Lordships have rightly pointed out to my learned friend that there are certain grounds for challenging a constitutionality of certain provisions. If Your Lordships would be humble enough to refer to the case of Namit Sharma versus Union of India, reported in the year 2013, paragraph number 10, Your Lordships.
Counsel, please formulate your points. We'll go to the judgment later. Please tell us what does the judgment say, and thereafter we'll permit you to refer it.
Indeed, Your Lordship. Indeed, Your Lordship. Your Lordship, in the said judgment, the 3 grounds that were laid down were legislative competence, and as the petitioners have already clearly stated that they are not challenging the legislative competence in the present case. The second ground being violation of fundamental rights enshrined under Part 3 of the Constitution, and the counsel would be elaborating further how none of the fundamental rights have been infringed in the present case. And third being reasonableness. And Your Lordship, the counsel would also be elaborating on the point that reasonable enshrined under Article 14 of the Constitution has not been infringed in the present case. If that satisfies Your Lordship, the counsel would move on to the first issue at hand.
Yes.
With the leave of the Honorable Court, the counsel would like to address the second issue first, which is pertaining to the constitutionality of sections 123 and 124. And through the course of arguments, the counsel would be establishing that not only are the provisions constitutional, but also the state is not obliged to produce the documents before the court, given the privilege under these relevant sections. Your Lordship, the first argument in this regard would be that sections 123 and 124 are constitutional and not violative of Article 14 of the Constitution. Your Lordship, in this regard, the counsel would humbly put forth that through a catena of judgments, including S.P. Gupta versus Union of India reported in 1981, followed by PUCL versus Union of India reported in 2004, and the very recent judgment of Yashwant Sinha versus CBI in 2019, the court has read down the provisions to a substantial extent that no arbitrary action can be taken by the state under the said provisions. If Your Lordships would be kind enough to refer to paragraph number 996 to 998 of the case of S.P. Gupta versus Union of India, it has been clearly laid down that the only grounds on which privilege can be claimed under section 123 is now national security and international relations. This being said, Your Lordship, in Yashwant Sinha also in paragraph number 8, this honorable bench has been very pertinent to lay down that the only basis for claiming privilege under sections 123 and 124 would be public interest. Now, Your Lordship, in the ambit of those 2 sections have been restricted.
Right, counsel, what we are trying to say is this.
Indeed, Your Lordship.
As to whether your action is bordering on public interest or not, is justiciable or not?
Indeed, Your Lordship.
Can you claim before the court, it is in my view that there is a public interest involved, therefore I will not disclose, or it is for the court to decide?
Your Lordship, the counsel very well understands the position that is being followed given regards to 185th Law Commission report in 2003, that the court has the discretion to inspect the documents at the prima facie level. But Your Lordship, the counsel would also contend that in the present matter, if reference may be made to paragraph number 5, with all due respect to Your Lordship, the technicalities and the complexities issued pertaining to the matter of no sources spyware, alleged the presence of no sources spyware in phones, demands an inquiry by an independent domain experts. And the state is very keen to constitute that body. And Your Lordship, the counsel would also clarify the stand that the state is not directing that body in any manner, and not even it is on state's directions that the body would be constituted. The constituted body would be of individual domain experts, and there would be no influence of the state, and therefore any kind of bias would be eliminated. If that satisfies your lordship, the council will move on to the magistrate.
What we want to ask you is this. Section 123 and 124 deal with the affairs of the state.
Indeed, your lordship.
Now, if the case of the petitioner is this, that this instrument spyware is being used on the citizens, on the private persons. Now, would that constitute the affairs of the state? If they don't constitute the affairs of the state, then you are duty bound to disclose.
Your lordship, the council very well understands the concern of your lordship. However, your lordship, the council would clarify and also reinstate that the petitioner themselves stated that it is not clear which particular authority or which particular body is using this spyware. Therefore, your lordship, on the very face of it, the state is not acknowledging the fact that the state is using the spyware on its citizens. The state is not even admitting that there is a presence of spyware in its very essence, your
That is
lordship.
where the problem comes. You see, let us go to the most fundamental question.
Indeed, your
Was
lordship.
this spyware employed by the government or a public officer? Was it employed by the government or a public officer?
Your lordship, the state would not agree to the fact that the spyware was installed by any government officer or public official, your lordship.
Therefore, the question of claiming privilege does not arise at all. See, the problem is you have not taken a stand.
Indeed, your lordship.
We have employed this spyware. We have not employed this spyware.
Indeed,
You
your
have not
lordship.
said both. Correct? If you have not said both, there are two methods of saying, yes, we have employed. One method of saying is to keep silent. Another method of saying it is, we claim privilege. When will you claim privilege? You will claim privilege only when you employ it. A person who has not employed it need not claim privilege. Correct?
Indeed, your lordship.
So how did you, where is the question of, 123 being invoked in your affidavit?
Your lordship, if you would be kind enough to refer to paragraph number 14 of the Moot proposition, while the council.
I will add one more thing to my
Indeed, your lordship. What indeed?
Milord's question. See, when you try to seek protection under 123 or 124, is it not an indirect admission that it is an indirect admission? Otherwise, why should you seek protection? This protection is based on public policy. 123 and 124.
Suppose I am a hacker. I have employed a spyware. I have intruded into your privacy. If you file a writ petition against the government will come and say, yes, we will investigate. We don't claim privilege. 123, 124 have nothing to do. Mr. So-and-so has done it. We will register an FIR. That is not what you are now doing. You are claiming privilege in 123 and 124 after refusing to accept or deny. Correct?
Indeed, your lordship.
How do you get over that?
Your lordship, at this point, the council would present two arguments. The first being that all the petitioner's claim are based on newspaper reports, and even your lordship, in arguendo, your lordship, if those newspaper reports are taken into consideration, nowhere do the newspaper reports mention the name of the state's involvement in these particular circumstances. Secondly, your lordship, if your lordships would even consider that the leader of the opposition stated that the no sources spyware has been sold to the Dharmastan police, your lordship, leader of opposition stated this on the floor of the house, your lordship, and such a statement is not admissible in the present circumstances. Thirdly, your lordship, in the very paragraph 14 of the Moot proposition, it is mentioned that there is a certain software and pertinence and details of that software could not be revealed. And the Advocate General has validly claimed privilege on the basis of security of the state and the documents being of sensitive nature.
No, see, in fact, that is where the problem comes.
Indeed, your lordship.
Paragraph 14, you have agreed to constitute a committee.
Indeed, your lordship.
What will happen to the committee's findings? After the committee's findings also, as per para 15, you are going to claim privilege. There is no necessity for a committee.
Your Lordship, that is the very, certainly Your Lordship, that is the very contention of the council, that the state seeks to maintain silence at this point, and the individual committee for itself would examine and inspect and inform the court, because it is under the jurisdiction of the court, and the committee would report to the court as has already been stated in paragraph number 14.
No, after the committee reports to the court, 123, 124 will be given up, or you will claim privilege?
The council begs your pardon, Your Lordship.
Now, after the committee files a report into court,
Indeed, Your Lordship.
will you give up the privilege claimed by you under 123?
Your Lordship, the very claim of privilege under sections 123 and 124 would work for the institution of the committee in the first place. And therefore, the claim of privilege ends when such claim of privilege has been recognized by the court, and the court agrees for setting up an individual domain experts committee in this regard. Therefore, Your Lordship, the claim of privilege question would not arrive at that point when the committee has already supported.
What we are saying is this: your argument is mutually destructive to each other. Now, the committee cannot go into the existence of the software. The committee's role is to say on the alleged misuse of the software.
Indeed,
If that is the case, can you still harp on and then still stick on to the so-called privilege which you want to exercise under 123 and 124 is what we are asking. Would you like to give it up? Now, see, you are entitled to take a stand, no problem. See, moment you say, yes, the committee is looking into it, then is it still open to you to stick on to the earlier stand by placing claims upon 122, 3 and 124? Therefore, can you just modify your argument to saying the challenge to 123 and 124 will be irrelevant, since we also agreed for the constitution of the committee, and the committee's finding will be binding on us. We have no issues on this, which presupposes the existence and usage of the software. As a council, we are telling you, but otherwise, you will be taking two diametrically opposite contentions. As a state, you can't suppose to take this. That's what we are asking.
Certainly, Your Lordship.
Please respond. So we want your views on that. Please.
Indeed, Your Lordship. Your Lordship, as the council will extend gratitude to Your Lordship for pointing out that the individual experts committee is for inspecting the very present.
May please note you have 4 minutes remaining.
Your Lordship, the committee which is set up of individual domain experts is to inspect the presence of no sources spyware and whether the allegations against the no sources spyware have a stand or not, Your Lordship. And the council agrees to Your Lordship that whatever be the report of the committee, the council would very well abide by that and would also abide by the wisdom of the court in this matter. What the council is just contending, Your Lordship, that at this very juncture, when it is not known what is the ambit of the documents that is requested by the petitioner, and given the fact, if we take in argument of the newspaper reports also in consideration, this CDT committee has been collaborating with Shangri-La, and this also brings the aspect of diplomatic relations into consideration, Your Lordship. And therefore, such documents cannot be disclosed, Your Lordship, in the present.
Council, understand one thing. Even though you are seeking this sought for CBI investigation,
indeed, Your
first
Lordship.
thing you will have to understand that this is a petition filed under Article 32.
Indeed, Your Lordship.
26 in Stratton High Court. Then one was filed under 32, and then all the matters pending before this High Courts were called transferred. And now, see, in a writ petition, you are also, see what is your pleading. And then the question is, once to meet the contentions of the petitioner, you have taken up a definite stand by way of your pleading. And can you, are you bound to stick on to that, or are you giving up that?
Your Lordship, the council is not giving up its argument in the present matter. The council sticks to the stand that the documents, given that they are very sensitive nature and security of
You
the
are
state.
sticking on to that. Now your contention is that you claimed the protection under 123 and 124.
Indeed, Your Lordship.
And then, see, to claim that protection, that particular document should be one which is related to affairs of the state. And
Indeed,
what
Your
is your understanding with respect to that expression, affairs of the state?
Your Lordship, as this very honorable bench has rightly laid down in the case of SP Gupta versus Union of India, as already stated by the Council, paragraphs number 996, this affairs of the state expression is now limited to national security and friendly relations with other nations. And this brings the Council to the second argument at hand, that because the ambit of affairs.
Understand that in that particular decision, Justice Venkata
Indeed, Your Lordship.
concurring the judgment of Justice Bhagavati,
Justice Fazal Ali
added something. Can you say that is explaining what exactly is the affairs of the state?
Indeed, Your Lordship. The Justice, as rightly pointed out by Your Lordship.
Please note, you have 1 minute remaining.
As rightly pointed out, this affairs of the state has been heavily and very elaborately dealt with in the case of SP Gupta versus Union of India. But Your Lordships, in the conclusive part of the judgment, it has been laid down that now the given position in the present matter and the evolution of democracy, this very section 123 and 124 would not be construed liberally and arbitrarily. And to restrict the very scope of these two sections, Your Lordship, the affairs of the state phrase has now only been restricted to national security and friendly relations with the state, which also seeks mention in under reasonable restrictions of Article 19(2), which brings the Council to the second argument that they are not violative of
This question was pulled. On hearing your first limb of argument, it appears to us that you are not actually claiming protection under 123 and 124. And if that be the case, now the provisions are provisions of IT Act. It is there. If any other person had committed that crime, now under the provisions of the IT Act, if there is an intrusion into the privacy, 66E is there, and then the provisions under IT Act 66, 66B is there, 66E is there.
And the very concern of the Council would be dealt with by co-counsel when he deals with the argument of right to privacy under Article 21 of the Constitution. However, the Council would like to clarify its stand that the Council is not agreeing to the fact that the Council is not claiming privilege under sections 123 and 124. All the Council is requesting before this court is let those documents not be produced because they are of very sensitive nature, and because the ambit of these documents are not known in the Moot proposition, Your Lordship, let these documents and the
one, may please note your allotted time is over.
One more question. If you are not saying that this particular document is not related to the affairs of the state, then please see section 91 of our CRPC. 91. The power
Someone to produce your documents. The Council is aware, Your Lordship. 91.
You know 91.3 what it is. 91.3.
Your Lordship, it pertains to summoning the documents related to any criminal proceeding. If a council is subjected to correction.
91.3.
For the assisting this court, should the Council read out the provision itself?
91 and see without going through 91, we are virtually taken aback. How you can argue this?
Your Lordship, the Code of Criminal Procedure, with all due respect, Your Lordship, the Code of Criminal Procedure applies to criminal proceedings where documents have to be produced by the other party. But what we are talking about, Your Lordship, in the present
if it is not at all a crime, why the other party is claiming a CBI inquiry?
Your Lordship, with all due respect, that is what now the Council is differentiating. The Council is just putting forth that a privilege in its very essence is an exception to the normal procedure. And therefore, Your Lordship, what the CRPC lays down is the normal procedure to be followed in any proceeding. However, since we are claiming state privilege under section 123 and 124, such should be an exception under the normal procedure.
Are you saying that CRPC is applicable only in cases of this crimes under the ordinary rules?
Indeed, Your Lordship.
Under the special rules, any other special rules, no, the procedure need not be followed.
No, Your Lordship, that is not the not the contention of the Council. The Council agrees to the fact that
Section 4.
Section 4, Your Lordship.
CRPC, if your contention is that no, that need not be followed.
Your Lordship, the Council is just seeking to distinguish this very case from.
If procedures are not specifically provided under the special rules, then which should be the law? The procedure which has to be followed. The one prescribed under CRPC.
Your Lordship, given the fact that the council subject to correction, your lordship. In a writ proceeding, since the Evidence Act is also not stricto sensu applicable, the council is not aware of the fact even if CRPC's the rule and procedural norms laid down in CRPC are stricto sensu applicable to the writ proceedings.
That can't be your answer. Your answer should be Section 91 CRPC will come into play after the registration of the FIR. We are at the stage where the petitioner is seeking the registration of an FIR. Therefore, at this stage, it does not arise, should be your reply.
See, we are putting all these questions only to not exactly for confusing you, but see here, definitely we will have to analyze your knowledge about it.
Indeed, your lordship, the council understands.
Yes. And
Your lordship.
You can ask the co-counsel.
Indeed, your lordship. With the leave of the court, the council would just sum up the arguments in 30 seconds.
All.
Your lordship, as according to the arguments, the council would be summing up these arguments in a fourfold manner. The first being that sections 123 and 124 are constitutional, given that they pass the muster of Article 14 and 19 of the Constitution, given that they are not unreasonable, and given that Article 19(2) provides for reasonable restrictions under which the privilege can be claimed. And secondly, your lordship, the government ought not to produce these documents, given that they are they relate to the security of the state and are of sensitive nature. And your lordship, the council will reiterate what the petitioner also has said, and your lordships have already recognized that the state's role in the present matter has not been recognized, and therefore the state denies any recognition and any connection with the no sources spyware, if there is such a spyware present. It was an honor pleading before this court.
I want to add one more. Section 4, besides Section 4, Section 5 of our CRPC also is right.
The council would go through the same.
But you will have to 5 words.
Indeed, your lordship.
Your co-counsel.
Greetings to the bench. Your lordship, with the permission of the bench, may the co-counsel commence with the pleadings?
Yes.
Much obliged, your lordship. Your lordship, the co-counsel shall be dealing with the remainder of the 3 issues. The first of which is as to whether the purported allegation against the state of Dharmastan with respect to the violation of the petitioner's fundamental right holds ground or not, which would have a concomitant nexus with the last issue as to whether a CBI investigation is warranted in the present factual matrix or not. Your lordship, in order as a precursory note before addressing the third issue, what should serve as a pendant to this court while considering these particular issues is firstly that the purported allegation is solely based on newspaper reports and has been adduced by forensic evidence which is unverified. Your lordship, the very genesis of this particular forensic report has not been verified and has not been verified by and has been not substantiated by my learned friends before this honorable court also. In this regard, while the council is council concedes to the fact that the rules of evidence would not be stricto sensu applicable. However, it is desideratum that a 65B certificate with respect to the Evidence Act ought to have been submitted, given that the evidence in question is the cellular device of the petitioner, which is a mobile phone and pertains to an electronic record. However, be that as it may so, your lordship, the council shall establish before this honorable court as to how...
Forensic report is not a cellular record. Forensic report is a report produced manually after examination of the cell phone of the complainant. That's all. Product. It's not a number one. Number two, there is the most fundamental principle is that what is not denied is deemed to have been accepted. Have you denied the use of this spyware in your counter affidavit for the court to call upon the petitioner to produce evidence?
Your lordship, while the stand of the state is that in the view that the petitioners have adduced evidence that is incredulous and the veracity of it can be questioned, your lordship, the council understands that the absence of evidence is not evidence of absence. Be that may as it may, however, the Moot proposition being silent on that aspect, the council is willing to contend the matter on the merits. And your lordship, the council shall prove before this honorable court as to how the fundamental rights have not been violated in this regard, your lordships. With the permission of your lordships, the council would...
No, if that is the case, Why are you denying it? See, nobody is saying that the use of the software per se is illegal. You are entitled to use this software for a particular purpose.
Most certainly, Your Lordship.
The Information Technology Act has been done also under the Telegraphic Act. So they have got this inbuilt mechanism available in other statutes also. Obviously, we're safeguarding the interests of the user. No problem on that. But it is strangely, you tend to condemn that you don't want to say anything about it. So it creates a strong presumption on the allegation made to the petitioner with respect to the possible usage for other purpose also.
Much obliged, Your Lordship. The council thanks Your Lordship for your question. In this regard, may Your Lordship kindly refer to paragraph, if Your Lordship kindly takes up paragraph 6 of the Moot Court proposition. If Your Lordships are with me, the council shall proceed to answer Your Lordship's question in specificity.
Yes. Yes.
Your Lordship, the very allegation is that, firstly, while we are all relying on newspaper reports, the petitioner has conveniently ignored the fact that the allegation, even in newspaper reports, is that this particular software has been used primarily to prevent terrorism, and allied antisocial activities. However, as the council understands Your Lordship's concern with respect to the silence of the state in this regard, Your Lordships will kindly appreciate that, Your Lordship, the whole aspect of a privilege, and the state is essentially considering the larger social interest in this regard. Whether even if the state accedes to the fact that it has this software, it would cause it would be pernicious to the larger social interest. Even if the state accedes to the fact that it does not have this particular software, it would be pernicious to the larger social interest. Wherein, Your Lordship, the state has maintained the grey ground, and in that regard, this would essentially be dealt with in the argument that while Your Lordships, an independent committee, which may be constituted under the aegis by the wisdom of Your Lordships, let that committee come to a finding first. The state will then take a stand and it will file a supplementary affidavit in that regard. Does that satisfy my lord's question?
All right.
Much obliged.
Understand? You're stopping. What question? See, the very case of the petitioner is that the state actually constituted this CDT.
Lordship.
Center for Digital Technology.
Lordship.
It was constituted by the government. And who are the persons included? Who are the members therein?
It is mentioned in paragraph 4 of the Moot Court proposition.
And when the allegation is that that particular CDT did these things.
Most certainly. Your Lordship.
You will have to argue realizing that exactly is the case of the petition.
Most certainly. Your Lordship, the council shall address that. With the leave of Your Lordships, the council shall address that in the 5th issue when it is dealing with as to why the CBI should not investigate the issue. However, presently, with Your Lordship's permission, may the council apprise this bench as to why a violation of right to privacy has not taken place. And Your Lordship, the council keeps in mind that the present petition is essentially at a very interim stage. So the duty of the state is to prove at a prima facie level as to why no violation has taken place. It is, of course, subject to what the report says, Your Lordship. Does the council have your permission?
No, that's all right. Now, the sum and substance of the case as projected by the petitioner is that there is not much of a difference between namely the state, and the private person, because the prima facie, if the contention is accepted, there is no need for challenging 123 or 124, or then your attempt to take umbrage under it. When a software which is procured unauthorizedly is being used unauthorizedly, it doesn't make a difference between an individual or a state, and the allegation is by a state, and in the absence of an affidavit, matter requires investigation, is what they're saying.
Lordship will kindly appreciate, and
the state authorities are allegedly behind this. Why not go for why not court order for a CBI inquiry? That is one of the another issue.
Lordship, Lordship, this I shall be dealing with this issue as per an issue which I have framed essentially to deal with this question. However, to address your Lordship's concerns at the present moment, your Lordships will kindly appreciate that with the involvement of the CBI, this would essentially, and your Lordships will appreciate that this is not a legal problem. It is a social problem. It is a practical problem. That with the involvement of the CBI, there would obviously be a question of bias. However, be that as it may, it would turn into a situation of political gimmickry. And to leave aside all that, your Lordship, the state is the parents patria of the people. To safeguard their interests, your Lordship, the state is also interested as to what is taking place. So let an independent committee who has the necessary expertise to deal with such a complicated software, which is the first of its kind, under the aegis of your Lordships, the wisdom of your Lordships, place its report before this honorable court. And as an officer of the state, I am putting on record before this honorable court that the state will cooperate with the agency in fullest. Yes. If that satisfies your Lordship's question, can the council move forward with respect to how a violation of the fundamental right to privacy has not taken place?
All right.
Much obliged, your Lordship. Your Lordship, firstly, the council differentiates between your Lordships, the council need not ask you to take up Article 21. However, for the sake of convenience, your Lordship, the very articulation of Article 21 is in a very negative sense. It is a negative right, your Lordship, that the right to life and liberty can be deprived only by procedure established by law. And that is where a fundamental right is curtailed. Without the absence of any procedure, it would be a violation. Your Lordship, herein, your Lordships will kindly take up paragraphs 407, 408 of 2019 Volume 1 SCC page number 1, which is essentially the K.S. Puttaswamy judgment rendered by this honorable court, wherein your Lordship, the court has recognized that national security is an exception to the absolute right to the right to privacy, of course, contingent upon due procedure of law. However, your Lordship, what will further the interest of national security is essentially a question of policy that needs to be determined by the state. The Lordships will also appreciate that a presumption of constitutionality, even with respect to executive actions, would also prevail on the state, in favor of the state, as per a perusal of paragraphs 42 and 43 of 2004 2 SCC page 476, which is the Lordship.
We are with you in this.
Lordship.
So, will you agree? Suppose we say, yes, state has employed the software, state has actually conducted surveillance, but it was done in national interest, protected. Shall we say that? Will you agree?
Your Lordship, as an officer of the state, it would be unprofessional on my part to mislead this honorable court in the absence of adequate instructions, which is why, your Lordship, it is also possible, as your Lordships has pointed out, that the conduct of the state over the years is not vociferous of such contentions. Your Lordship, the state is open to investigation. Let your Lordships find out. Your Lordships may Lordships.
Why should we find out? See, it concerns national security.
Lordship.
If you say, yes, we have employed the software, we have conducted surveillance, but we did it in the interest of national security, we will close this case. But you must make a statement.
Your Lordship, the very moment that the state makes such a claim, it would be pernicious to the larger social interests in ground. The moment the state makes such a claim in open court, your Lordships will kindly appreciate that the very intent of such a software, which is to tackle antisocial elements, will come to know that the state has such softwares and they are using it, and they will take adequate measures.
What will the committee do then? What will the committee do then?
Your Lordship, the committee will, of course, assist this honorable court, and the committee will be a private committee. It will submit its report to this honorable court, be it may in a sealed cover. The sealed cover practice has been prevalent in this honorable court.
This proceeding is not sub rosa. This is not sub rosa, not in secrecy.
Most certainly, your Lordships. However,
in the context of that question, whether you have gone through Section 5(2) of the Telegraph Act,
most certainly, and your Lordships,
the legal regime for surveillance.
Lordship,
for what? For public safety.
essentially two tests are laid down as per a bare perusal of sections 5 to your lordship, that it must warrant or further a cause of in the light of public emergency or further the interest of public safety. Your lordships, these aspects, again, your lordship, what furthers the cause of public safety is essentially a question of policy, and this has been taken note.
I don't understand on that. That is why this question was put.
Your lordship will also, your lordship, may the council kindly request your lordship to kindly repeat the question. The council was not being able to hear your lordship.
See, the question is section 5.2. You know, it says that, or it is actually a legal regime for surveillance in the interest of a public safety.
Lordship.
Do you have such a case? This has been employed for in the because of that.
Your lordship, that would be a case that a council would make in the last resort, because the moment council accedes to that fact.
We put that question because
lordship,
it appears that you are actually seeking protection under section 123 and 124. That is why this question was put.
Most certainly, your lordships will also appreciate that the ultimate discretion with respect to even sections 123 and 124 lies with your lordships. If your lordships direct us that to produce the particular documents in a sealed cover, your lordships, the state dare not so violate this particular order. However, the state is only requesting, and your lordships will kindly keep your hearts open that the state is trying to protect is trying to protect a larger picture in mind, which is, your lordship, the welfare of the people. Your lordship, tomorrow, if the state was not going to exist, your lordship, what would the fundamental rights do, your lordship? Your lordship, the council will address your lordship's concerns on this regard. However, your lordships will kindly appreciate that even in arguendo, if a prima facie case had been established by my learned friends from the petitioner side that it is the state who is employing this particular software, the same would pass the muster of proportionality. Your lordship, as has fallen from your lordship, that there is valid law which warrants the state to undertake such an action, which is essentially fulfilling the first ambit of proportionality, which is that the existence of a legislatively enacted law. Your lordships will also appreciate that section 69 of the Information Technology Act essentially gives the power to the state, of course, upon certain considerations, and the order must be reduced in writing, that monitoring and surveillance can take place, your lordship. However, your lordship, in the current factual matrix, your lordships will kindly take up paragraphs 30 and 31 in page 11 of the memorial presented on behalf of the respondents. If your lordships are with me.
Yes, please. Yes, please.
Lordships, over here, a concept called the parens patria, which is, it's not a concept, your lordship, it is a reality, has been espoused. Your lordship, it is in compelling state interest therein that this particular defense is being put forth. And your lordship, it pertains to national security, and time and again, as has been reiterated by the council, what advances national security is a policy decision, and your lordships have accepted to that, which essentially brings me to a very important aspect. Your lordships, a perusal of paragraph 5 of the Moot Court proposition would essentially reveal the very invasiveness of this software. This particular software.
You are trying to extend the principle to a much higher degree. The principle of parens patriae will apply to an individual who has got nobody else to take care of, and with a corresponding duty on the person who is bound to take care. Here it is not so. Here the very allegation itself against you. Lordship, parens patriae will come.
Lordship, herein, if your lordship is referring to the last...
On the general principle that state exists for the citizen, there's no difficulty. But what extent is this issue?
Your lordship, herein the state is...
Another fallacy is state exercises parens patriae jurisdiction.
Lordship.
Citizens other than the writ petitioners.
Lordship, Can your lordship kindly repeat the question? The
Is
council
the
begs
repeti-
pardon.
Does the state have parents petri obligation towards the writ petitioner also or not?
Most certainly, your lordship, the state is
That's
concerned
right.
about
That's
the.
what their complaint is. My parent is distinguishing between me and other people.
Your lordship, which is why your lordship, while the parent also has to be cautious with respect to what the citizen or the petitioner herein is alleging, which is why, in order to go into the veracity of the details, your lordships will kindly appreciate that the chain of events in the current factual moot problem is incoherent in itself with respect to its veracity. These are all newspaper reports, and while your lordship, some newspaper reports support the state.
We understand what you are saying. See, this principle has to be applied when it comes to a public interest as against a private interest, according to you. Even assuming there is an apparent conflict, you must see the larger public interest in that.
Lordship, most certainly, your lordship, which essentially.
See, if you have to wind up your argument, can we sum up your argument? Your argument, your response to the writ petition is, I will not tell you whether I have done it or not. You please constitute a committee to find it out. In case you find out that I have done it,
Then
give me protection under 123 and 124. I am exercising parents' petria. I want protection.
Most certainly not, your lordship. The state does not want a rerun of the emergency situation in this country. Your lordship, what the state is saying, that your lordship, the state is concerned about the petitioner. Your lordship, the facts of the present case, it is unverified. Let the independent agency, independent committee consisting of dominion experts in this particular field, technological experts, come before your
Speaker
lordship.
2, may please note you have 4 minutes remaining.
Thank you. May come before your lordships and cement the facts in its entirety and its precision before your lordships. Once that is done, the state will take a stand, and your lordship, as an officer of the state, I assure your lordships that if it is detrimental to the petitioner in any way, the state shall not take any garb under 123 and 124. Be that as it may, your lordships have the final discretion whether to grant 123 or 124 in that regard. Your lordship, may the council come to the aspect of how the least intrusive measure has been complied with.
Yes.
Much obliged. Your lordship,
Welcome it, because if you have employed least intrusive measure, you are at least admitting that some measure was.
I beg your pardon, your lordship.
No, we welcome you to the second aspect, because you are now going to the aspect of least intrusive measure, correct?
Your lordship, that is in arguendo, assuming arguendo that a prima facie case has been established by the petitioner.
All right.
Your lordships will also appreciate that the onus over here is on the petitioner to impress the lordship.
Yes, please.
Lordships will also appreciate that the impetus and the onus is on the petitioner to come and prove before your lordship that there has been a violation which goes to the very root of his fundamental rights. However, assuming arguendo that such a claim was made, my lords will kindly peruse the case of K.S. Puttaswamy again, wherein your lordship, Justice Bhushan's remarks with respect to what amounts to least intrusive in paragraph 814 assumes significance. Your lordship, Justice Bhushan says that in complex circumstances, what is least intrusive must be determined by experts. And your lordship, this is again with respect to the concomitant nexus between the prayer of the state in this regard to constitute an expert committee under the aegis of this honorable court. Your lordship, fourthly, with respect to your lordships will also appreciate that the present, in today's day, your lordships will also appreciate the factual milieu and not merely the factual circumstances. Your lordship, terrorism in its present day is not limited to its primitive form. Your lordship, terrorists sitting in Syria are influencing people who are in Kerala merely through the internet, cellular devices. So, Your Lordship, such restrictions must be in place. Be that as it may, Your Lordship, with respect to the fourth term, which is a
Speaker 2, may please note you have 1 minute remaining.
much obliged. Your Lordship, may the council kindly beg before Your Lordships for a 2-minute extension so that the council can sum up his issues.
No. Now please sum up, because we have not granted extension to other people.
Lordship, which would essentially bring me to the aspect of compensation, Your Lordship. Look at the Your Lordships will kindly look at the compensation which the petitioner is asking. It is 50 lakhs, Your Lordship, and horrendous, an exorbitant amount which the public exchequer has to bear, given that even a prima facie case with respect to violation has not been established. Your Lordship, with respect to differentiating as to why a CBI investigation may not be warranted in the present case, as Your Lordship has correctly fallen from Your Lordships, that a complaint has not been made before, an FIR has not been made. Your Lordships, the supplied facts and materials do not make out the commission of an offence, which is a quintessential requirement as recognized in Common Cause versus Union of India, that facts must warrant to the commission of an offence. Your Lordships, consent under Section 6 has been revoked. Your Lordship, the moment CBI proceeds to investigate the present matter, it would result in a political gimmick, which must be prevented by this honorable court. And thus, Your Lordships will kindly appreciate that that an independent committee who are experts in this particular domain may be requested to cementify this particular.
We take it that whatever may be the report of the committee, you will abide by it. You will not challenge it.
Most certainly not. How can Your Lordship, the state, challenge Your Lordship's wisdom? The committee will be under Your Lordship's wisdom.
You are saying about the report of the committee. What about the final report of the committee?
Your Lordship, that is a very slippery question for the council of the state to answer. Essentially,
No, you can answer. You can answer that if the committee's report is favorable to the government, they will accept it.
No, not never, Your Lordship. If the committee's report is favorable to truth and
Speaker
justice,
2,
the
may
government
please
will
note
accept it.
your allotted time is over.
Oh, fine.
Thank you. May the council just recite the prayer, Your Lordship.
Yes,
Just
yes.
the prayer.
Yes.
Much obliged. Your Lordship, in light of the facts presented, issues raised, the arguments advanced, and the authorities cited, my lords will firstly kindly dismiss this particular petition, as my co-counsel has already established that it lacks merits based on evidentiary value. In the alternative, Your Lordships will kindly hold that the state can claim privilege under sections 123 and 124, and Your Lordships will kindly bear in mind that this is a larger social interest that we are talking about. Your Lordship, thirdly, sections 123 and 124 pass the muster of constitutionality as has been held by the previous Supreme Courts in this regard. Fourthly, Your Lordship, even on a prima facie basis, the fundamental right of the petitioner has not been compromised in this particular case, which essentially makes no case of compensation for the state to make. Lastly, Your Lordships will kindly appoint an independent committee of domain experts to find out the truth and veracity in this particular factual matrix, and pass any other orders in the interests of justice, equity, and good conscience. And for this act of kindness, Your Lordship, the state shall forever remain grateful before Your Lordships. Much obliged, Your Lordship. It was an honor pleading before your bench.
With the honorable bench permission, shall we begin the rebuttals and rebuttals?
Yes.
The petitioner side may start their rebuttals.
What is the time allotted till them?
So they have 5 minutes for rebuttals and 4 minutes for rebuttals, sir.
Okay.
May I begin?
Yes.
Yes. All right. Thank you, Honorable Judge. So there are 4 main points that were raised by the respondents today's case, where they said about the constitutionality, the production of documents, whether violation of privacy, which they linked it to this CBI investigation independent committee point, and the last is the matter of compensation. Each of these points raised by the respondents have loopholes which they themselves created during the oral arguments, where they continuously kept going against their own logic of what they were trying to say. In the first case of constitutionality, though it has been mentioned that the applicable procedure has been read down and it has been interpreted in a different way, my learned friend, the counsel for the respondent, is not mentioned as to how it has been read down and what is the applicable procedure. Even in that regard, going by their very own argument, the present text of the language still remains the same, wherein wide discretionary powers are given on the executive to decide matters, and there is no given considerations that must be kept in mind with regard to public interest as well as affairs of state. The second issue was regarding the production of documents, which was I believe the most confusing issue, because while at the same time there is no stance taken by whether or not there was use, and there is also they admit that there is a need for an independent investigation in the case. There is no mention as to why exactly the balance of interest tilts towards their side. Affairs of state also includes matters of national security. That is not contended in, because it's been expressly held in judgment, that is not contended in any place. However, why is it that in the presence of the absolute lack of clarity, in the presence of there's no clear answers to questions raised, and in the presence of the larger public right to know, why should the specter of national security that they have raised, why should due regard and higher regard be given to them in this case has not been mentioned. They've even gone as far as saying as to whether no sources exist or not is not aware, and even as to whether documents stating no sources exist or not is not aware, which is counterproductive to the very point of raising a privilege under section 123 and 124. The third and the very important argument is that of the prima facie violation of privacy. Prima facie violation of privacy has been established in this case because of the forensic report showing signs of no sources. Here, they repeatedly kept claiming that the state has no role in this case. Here, regardless of whether the state has used resources or not, the state indeed has a role to play, because it is their responsibility to assuage the apprehensions of the citizens when it comes to matters of fundamental rights. This they have reflected in their own plea of asking for an independent committee of domain experts, where they have recognized that this is a matter of concern, where the lack of clarity, where the vacuum that they themselves have created, which is now going to become an echo chamber, they have realized that there is need for clarity on this matter. There is need for an impartial investigation here. On the point of the independent committee, the original prayer given in the proposition was that the government, that is the state of Dharmastan itself, set up the committee. But now that the learned friend has very kindly agreed to a committee set up by the court, the petitioners also don't see why our apprehensions of impartiality and credibility won't be satisfied by the same. Hence, the petitioners also agreed to an independent committee set up by the court. The last is the question of compensation, which
Just sum up your argument. See, right to open and transparent governance, does it constitute a fundamental right or not?
Yes, Honorable Judge.
Concentrate. You just sum it up. You just sum it up. Just bring it to the core issue, then put it to us. Just because you were rebuttal, you need to sum it up. You have to collate all your points and just tell us what you actually want.
The only thing that we
want about the arguments made, then from the arguments made by you from the other side, just deduce it and then tell us.
This is my summing up argument, Honorable Judges. That is the who, why, how of no sources is not known neither by the respondent nor by the petitioner, and this can be known only by the prayers asked for by the petitioner, which is the production of documents and the impartial investigation. And this is my final argument.
Are you saying it with very seriousness? You do not know who, how, and why.
Still
you are claiming compensation.
Honorable Judge, as explained by my co-counsel, the claim of compensation will be only after due procedure has been followed. That is the case of the investigation. And
now tell us, why do you seek compensation? Now you say you are filing as a private interest or public interest? You Article 32, right? It's public litigation. Where is the question of compensation for you? As a compensation is for the entire society to know that government has faltered, is more in the nature of fine, or individually you want it? What is the logic behind it? Tell us.
I believe it's a mix of both, wherein not only the petitioner suffered injury, but also on top of that, considering how unprecedented this is, the level of invasiveness that this is, there's a need to send a message.
Has to be given to all the citizens of the country, of the state.
This case is particularly unprecedented and peculiar than compared to any other cases or matters of routine.
All right.
I rest my arguments right now.
The respondent side may start their rebuttals.
No, sir.
Okay. Yes, yes.
With the permission of your lordships, may the council commence with the sir rebuttals? Much obliged. Your lordship, firstly, your lordship, my learned friend has erred and grossly misunderstood the entire pleadings of the state. Your lordship, while the contention of the respondent with respect to why article sections 123 and 124 should not be struck down is essentially because its very scope has already been read down several times by this court, most prominently in SP Gupta versus Union of India, which my co-counsel has already established. Your lordship, the procedure has been laid down, and any affairs of the state has been restricted to only two aspects. One is national security, the other is friendly relations with foreign countries, which essentially is resonated in Article 19, Sub-Article 2 of the Constitution of India. Your lordship, with respect to what my learned friend said with respect to how the state's position lacks clarity, may the state then clarify again before your lordships that your lordship, the presence of the Nososis software is not disputed, as we are all relying upon newspaper reports. Your lordships, the Nososis software is present. What is disputed by the state herein is the software being used by the state. Your lordship, that would be pernicious in nature, given that if we reveal that the software is being used by the state, it would notify certain people. If we reveal that the software is not being used, it would be used in advantage by certain antisocial elements. Your lordships, therein a neutral stand has been maintained, and it has been prayed that an independent committee may investigate into the matter, because the state is interested in serving the petitioner with justice, your lordship. Your lordship, thirdly, with respect to the forensic analysis report, your lordships will kindly peruse paragraph 11 of the Moot Court proposition. It simply states that Nososis was present in the petitioner's phone. It has nowhere been explicitly mentioned that the state was using it in all the newspaper reports, your lordship. In fact, your lordship, a very pernicious aspect can be brought out by the state herein, where your lordships had correctly pointed out that the petitioners may have certain pecuniary interests herein. Your lordships will appreciate that in paragraph 5, Dharamsthan Times, which is a leading newspaper, had first brought out the report with respect to Nososis, and it is the only report which alleges certain nexus with the government. Suddenly, your lordship, in paragraph 11, on 7th of August, your lordship, the petitioner comes up before this honorable court with a forensic report, and he's citing his own newspapers as evidence. Your lordship, coupled with the fact he's asking for 50 lakhs of compensation, your lordship, this is public money. Your lordship,
see, if you are concerned only about 50 lakhs, we'll straight away reject it. Other two prayers can be allowed.
Your lordships,
don't focus on 50 lakhs. Money is not the primary issue.
That is only consequence.
your lordships, it is the humble understanding of the council that the court is not at a stage to decide whether the other two prayers can be allowed, essentially because this is an interim stage.
So why we are in a dilemma? We'll tell you why we are in a dilemma.
Lordship.
You filed a limited affidavit.
Lordship.
You are agreeable for a committee.
Lordship.
Just tell us in one sentence, what could the committee find? What is expected of the committee to find? Just the presence of the malware in certain phones, or the use of the spyware by the government? What is expected to be found out by the committee?
Your lordship, two things are to be found out by the committee. Firstly, the committee will find out the invasiveness and as to how the particular software works and verify its very presence. And secondly, if at all there is scope of its use by the state, that being established, this would be in a perfect place to adjudicate. Your lordship, that is not a question of law, that is a question of fact. Your lordship, this is a court of equity. Your lordships are concerned with as to what the law is.
Therefore, it is within the scope of the committee to say that the state used it.
Most
In case
certainly.
they find.
If they come to that conclusion, most certainly, your lordship. However, your lordships will kindly appreciate what my learned friend had stated, that I was
Is such a defense a plausible defense for the government, rather than an outright denial in the first instance, and to prevent an investigation from being conducted?
Your lordship, that is essentially because, your lordship, this is a moot court proposition, and
You have no control. You have no control over it.
your lordship, the council is bound by the moot court proposition, which limits the council from taking any stand. Be that as it may, your lordship, in paragraph 14, your lordship, I am not taking a contrary stand. Your lordship, the advocate general in his supplementary affidavit has told the chief justice that
Participant, may please note your allotted time is over.
I shall wrap up with the permission of your lordships.
Yes.
Your lordships, the advocate general has taken a stand that the state is open to a committee by independent domain experts constituted by your lordships. Your lordships, lastly, one final issue, that the presence of no sources as per newspaper reports, your lordship, such newspaper reports being the veracity being disputed, it cannot be prima facie, it cannot be established that the state has been using it. Thus, your lordships will kindly allow the fifth prayer of the respondents and direct investigation, expert committee investigation into the matter. Much obliged, your lordships. It was an honor.
As it is arguing before the Supreme Court.
With the permission of Honorable Bench, shall we proceed to the feedback session of the final round of the 31st National Moot Court Competition? We invite, excuse me, your lordship.
No, the arguments are over.
Yes.
Indeed, your lordship.
Okay, rebuttal, surrebuttal, everything is over.
Indeed, your lordship.
Okay.
Now,
Eight fees and connected is posted to so and so. Hearing before the Supreme Court of India.